Today we're talking about Miranda rights, specifically what they are, when they are required, and what happens if they're not read to you. So a while back the Supreme Court said that the police need to inform you about your rights, your right to remain silent, your right to refuse questioning, your right to counsel, and those types of things. You probably have heard those Miranda rights many times in the movies and Hollywood on TV shows and those types of things. In reality, they're not as strong, they're not as protective as many people might otherwise believe. So people come to our office very frequently and they say, hey, I was arrested, but the police never read me my Miranda rights. Does that mean my whole case gets dismissed? No, not really. That's kind of a Hollywood thing. In reality, what it means is that those statements, certain things that you said, certain questions that the police asked you and your answers to those questions may not be admissible against you, but the other evidence still can be. So let's take a look at when Miranda is specifically required. Supreme Court has said that two things need to happen. One, you need to be in custody. So if you're not in custody by the police, they don't have to read you any of your Miranda rights. They can just ask you questions freely. The other thing is if you are in custody, they need to actually then be interrogating you. They need to be asking certain questions. So, and it needs to, the questions need to be specific. They need to be moving towards basically eliciting evidence, eliciting statements from you that can incriminate you. And once those two things are in effect, so the police have you in custody and they are interrogating you, then they need to Mirandize you. They need to read you those rights, make sure that you acknowledge them or that you waive them and you want to answer those questions. And so that's the formula that we learned in law school. It's kind of the general framework. It's called custodial interrogation is when Miranda comes into play. But that's a pretty broad, pretty generic understanding of it. Let's break it up a little bit further. So what actually is custody? It's a little bit hard to explain, but really what it means is that you're not free to go, you're not free to leave, your freedom of movement is a little bit impaired or there's kind of a gray area there. So most people will recognize that if they're stopped by the police, they're probably not free to go. And so that would consider that to be custody. That's kind of on the one end of the spectrum. The other end of the spectrum is if once you're arrested, you're in jail, you are locked in a room for questioning, that's obviously very clearly custody. So there's a little bit of a spectrum there. But that's when you're in custody. When you're in custody, when you're not free to leave, when your freedom of movement, your freedom to go about and do your daily business is impaired or impeded, that's when you're in custody. The next question is, when are the police actually interrogating you? So let's say, for example, somebody's arrested, they get stopped on the side of the road for a DUI. The police put them in custody. They put them in handcuffs, they're under arrest, they're in the back of the police car, and they're being transported somewhere. At that point in time, they are in custody. But the police, if they're not asking them any questions, they're not being interrogated at that point, and so Miranda doesn't apply. If the police started asking them questions about certain things, they would need to Mirandize them because those are questions about how much they had to drink and those types of issues. That's when these two elements would come into play and then Miranda would be triggered. Interrogation is also when they're asking questions purposefully meant to elicit a response about the about the crime. It doesn't include regular kind of background information. So information about your name, your address, your date of birth, identifying information, certain kind of low-level questions are not considered to be interrogation. It needs to be a little bit more specific. It needs to be a little bit more detailed and pointed to get to the nature of the underlying offense or something else. And if those two things are happening and Miranda comes into play, then anything else that you say after that point in time can be used against you. Where we see problems with this is when these two things are in fact happening, but the police did not Mirandize somebody. Now they want to use those statements against our client or against the defendant. They can't do that because those were statements made without being Mirandized. They're inadmissible. But if these two things happen and they Mirandize that person and they ask him, how much did you have to drink? Were you the driver? Did you feel intoxicated? Did you steal that candy bar? Whatever the issue is, then those statements can come into court. If there's a violation of Miranda, it doesn't mean that the whole case gets dismissed. It just means that those statements are not admissible against you. So that's how it works. People, they have a question. They see this in the movies all the time. The police may not have actually read somebody their Miranda rights, but that doesn't mean that your case is going to be just thrown out. It just means that certain statements may or may not be admissible or be used against you. One more quick important point. Miranda has been kind of narrowed and kind of refined over many years. And it's now required that your statement to the police is unambiguous. If you do want an attorney, if they're Mirandizing you and they say you have a right to an attorney, you have a right to remain silent in those things, and you're ambiguous about it, and you say, I think I might want to speak to an attorney, I don't know if I need a lawyer, I'm a little bit confused about those things, that may not invoke your right to have an attorney. It may not cease the police questioning. Instead, it needs to be extremely unambiguous. And so we have on our business cards and a lot of our other advice, you have to say, I want to speak to an attorney, I want my attorney. That is unambiguous. The police have to stop their questioning. You have a moment to go speak with an attorney, give our office a call. So that's how that works. I hope that helps answer some questions. For a lot of people, it's not the answer that they want. They would like their entire case thrown out. So would we. But quite frankly, this is an issue that we hear frequently, so I wanted to make sure that everybody understands how that works. If you think you have a Miranda issue, if you've watched this video and you say, hey, I was in custody and they interrogated me, but they never Mirandized me, give our office a call so we can talk about what statements you may have made or what came out as a result of the police line of questioning that we can get thrown out in your case. Thanks for watching.